Thank you very much. Thank you for invitation. It is always good to be here and feel as at home. And today I would like to share with you some impression on the constitutional basis for migration and refugees in Poland. And I think you could more understand our approach, Polish approach. Probably. And in my presentation, I would like to show the framework of the legal basis of migration and refugees issues in Poland. Then consider which of the principles of the state in the constitution are attached to migration and refugees. And finally, I would answer how to the status of the migrants is regulated in the Polish constitution. Let's start from this formal legal basis. So where we are searching the legal basis for migrants and refugees issues in Poland, we have to start, of course, from the constitution, and this constitution approach is very important in Poland. The constitution is an act with the higher force of the state, and for this reason it sets a framework for operation of the public authorities, including those related to the individuals of the state. So we have a special provision that the constitution is the supreme right, and as you see, it is because of the constitution. It is nothing of interpretation, but it is a provision of constitution. A second act is statute. So the statutes of the same acts of parliament develop provisions of the constitution, and it is the most important source of law for practice of courts and administrative bodies, and they regulate issues in details and can be the base of legal decisions and judgments. And the most of things on refugees, migrants, and so on are regulated in Poland in this statutes, acts of parliament. But we have to remember that at the same time, the constitution maker provided for the obligation for Poland to comply with international law, binding on it. So not all international law, but binding on it. And the same as with EU law, because it is international agreement that makes Poland bound with this law. The treaty is ratified international agreement with acceptance of parliament or of the nation. And it should be remembered that usually international law or EU law provisions are not self-executing. And it is to the state to implement or to precise it in domestic source of law. So often, even if the content of the acts comes from international law or EU law, it has form of domestic act, so the statute. So this provision from international law, EU law are in domestic source of law. And looking on international law and in some cases on EU law, the state has to follow certain standards, directions and policies shaped on this level of legislation, but the state also has to fulfill its international obligations, but it is up to state's government to choose how to make it. And it is approach and thinking written in Polish constitution. When we are thinking of the position of migrants, we have to see the principle of the state connected with migrants and refugees. What is this constitutional framework? In order to answer the question, it is necessary to look at some political principles of the Republic done in the Constitution, and I choose 3 of them, which in my opinion shows the essence of the problem. So first is the principle of sovereignty of nation, then principle of common good, and third, principle of dignity. And let's see the first one, the principle of the sovereignty of the nation. Constitution of Poland is established by sovereign, which is a nation. And it is clear from the preamble to the Constitution that all citizens of Republic of Poland are the nation. So we have connection, citizenship and nation as a sovereign. Then we have to go to common good. First article of the Constitution says that Republic of Poland is the common good of all citizens. Again, not everyone, but citizens. So the citizen is therefore the basic subject of all activities of public authorities, as state has special obligations towards him or her. And a person with the status of citizen is part of collective subject. The sovereign participates in shaping the will of the state, enjoys certain freedoms, rights, and has certain duties, and is surrounded by the protection of the state. Third principle of dignity, opens Polish constitutional system to all people. And it is compatible with the obligation to the state to protect human rights, so rights of citizens and foreigners. Yesterday, Professor Marcin Wielec gave us the definition, and I will follow this definition. So even the Constitution aimed at the implementation of common good as a good of citizens of the Republic of Poland, it does not leave other entities unprotected. And here is the sphere for migrants and for, of course, refugees and other foreigners. And it results from the universality of human rights, the source of which is dignity, and this obligation to comply with international law that is binding on it. This is expressed in Article 37 of the Constitution, according to which anyone being under the authority of Polish state shall enjoy the freedoms and rights ensured by the Constitution. But exceptions from this principle with respect to foreigners shall be specified by statute. And the legislator does not have any discretion in determining these rights. An act limiting the exercise of freedoms and rights guaranteed by Constitution has to be consistent with the Constitution and the values expressed therein, including such rules as principle of adequacy, principle of proportionality, or principle of equality. This means that migrants and refugees who are in the territory of the Republic of Poland can enjoy the constitutional freedoms and rights granted to all, so without distinction to citizenship, and while their rights must be developed in statutes, and they should therefore be treated as foreigners. In order to determine the status of migrants in Polish constitutional law, it is necessary to remind that in international law, it is assumed that all persons residing on territory or a given state are subject of its jurisdiction. And what is important, that the obligation to guarantee to the same extent freedom and rights to all citizens and foreigners residing on the territory or of given state and apply primarily to personal rights, and other rights, especially political rights, can only be granted by the state to its citizens, especially if it exercises the right related to sovereignty. And it should be also noted that the rights and freedoms of political nature closely linked to relationship of citizenship attaching the individual to the state should not be granted by the legislator to individual who don't possess the citizenship. And it is the justification of principle of sovereignty of the nation. Of course, we can grant to the foreigners such of rights, but on the statute level, and they have no such strong protection as on the constitutional level. But apart from this, the legislator has ensured that, however, is under the authority of the Republic of Poland, enjoys the freedom and rights guaranteed by the Polish Constitution. The special arrangements for foreigners are set out in Article 67 of this Act. Foreigners may exercise right of asylum in the Republic of Poland in accordance with rules laid down in the Act. Again, the base, so the right to asylum is constitutional right, but the details should be written in the Act. And second one, the foreigners who seeks protection from prosecution in the Republic of Poland may be granted refugee status in accordance with international agreement binding on the Republic of Poland. We have special statutes on the foreigners and on helping foreigners, and these matters are regulated there. But we have a lot of problem in interpretation of Constitution. What does it mean that, for example, foreigner who seeks protection from prosecution in a Republic of Poland may be granted refugee status? What does it mean protecting from prosecutions? We interpreted it in our administrative courts, interpreted it in a very wide way, not exact to protect against criminal danger or something like that. And what is interesting, Article 56 can be the pattern of control before the Constitutional Tribunal according to constitutional complaint. So if I am a foreigner, I can go with complaint to the Constitutional Tribunal, but if I want to complain on on violation Article 56, I cannot do it. So because of that, there is no jurisprudence on these cases. And to conclusion, I would like to say that findings led us to this sum up remarks. Polish Constitution does not mention migrants as such, and the concept of a refugee appears in the context of the right to obtain the status based off this Article 56, but legislator did not leave this person out of the interest. Indeed, migrants and refugees as foreigners are covered by Polish law and its guarantees, including constitutional guarantees as fair trial, appeal to ombudsman, and so on and so on. Even constitutional complaint, but apart from this Article 56. Secondly, the subject of constitutional freedoms and rights assured to everyone can be migrants and foreigners by virtue of their personal dignity. So this people, foreigners, could exercise this fundamental law attached, connected with speech, movement, and so on and so on. And shaping the position of migrants and the refugees must comply with constitutional standards, including the general principles of loyalty, proportionality, equality. A review of constitutional provision and on human freedoms and rights make it possible to conclude that foreigners too, they have the guarantees. And I leave an open question: if the shape of constitutional provision is enough today to cope with issue of migration, migrants and refugees, to protect them and guarantee safety and public order in the state. You know, in Poland we have a problem with this relation between constitution and international law. Formally, constitution is the supreme act, and Polish Constitutional Tribunal had a few verdicts, judgments on these cases, but they concerned the state's matter and transfer of competencies which are not shared. So there is not judgment on comparing or this conflict between EU law and constitution on migration and fundamental laws. Of course, we have this problem with impartiality of judgments, and it is showed as a problem of fair trial, but in fact it is an institutional problem, not the problem of the human rights. So it could be asked if the problem of migrants, migration, refugees is an element of constitutional identity or national identity. And in my opinion, it should be reflected, because nowadays judgments of Constitutional Tribunal are not enough to set that it is the part of it. Of course, because we cope with different part of problem, institutional part of problem, not this kind of problem with shared competences. So it is the case of Polish constitutional law, and I hope you understand a little bit more why we have this kind of thinking on these migrant cases. Thank you very much.